And we are live. Perfect. Well, hello everyone. Welcome back to another episode with an immigration attorney. We have Daniel and Deshna here with us. Today, we are going to be covering the new H-1B proclamation update about the $100,000 fees that employers were mandated to pay last month. Like it was a new proclamation that was signed on 19th of September, which effectively went into effect on 21st of September. Now we finally have an update on how things will happen with change of statuses, amendments, extensions. All of these three things have been ruled out by saying that they won't be applying the $100,000 fees to all these three cases, which means that essentially if you are here on your OPT, on your F1 visa, J1 visa, if you're here on a legal status, if you change your status to H-1B, you will not be affected by any of these. We will be answering bunch of questions both on YouTube and Instagram, but it will be better if you just join our YouTube. I'll mention the link down in the comments, but if you can just join it on YouTube, and we will take each and every question from there for the next 30 or 40 minutes. I'll just hand it over to Daniel and Deshna if you want to introduce yourself, everyone.
Hi, my name is Daniel Larson. I'm an immigration attorney, and I've been practicing immigration law for 10 years. I mostly focus on EB-1A, NIW, O-1s, and also many of my clients are in H-1B status. So I'm very familiar with the issues that are associated with H-1B. My legal assistant, Deshna, she's a UC Berkeley alum, and she can introduce herself.
Hi everyone, this is Deshna. I've been working with Daniel for over a year now, and as Daniel mentioned, I did my Master's of Law from UC Berkeley, and would be happy to answer any questions that you have.
Yep. Why don't you just give us a rundown of what was just recently announced in the notice, like an updated notice or the memo that we just got, and what's it all about?
Sure. So a couple of days ago, the USCIS on their website issued clarification on who the $100,000 fee would apply to. This was actually they did not. I found this to be highly abnormal in that usually when they make these kind of policy updates, they usually issue a memo. In this situation, they did not issue a memo. They just updated guidance on their website on the H-1B. And if you go to the website and you click on the presidential proclamation on restriction on entry of certain non-immigrant workers, they talk about who this fee applies. But what was really, back on September 19th, we had no idea whether change of status, extensions would be counted on this new rule. They have clarified and said that changes of status or extensions of stay or an amendment of an extension of stay are completely fine if you're here physically in the United States on a valid status. So this is a tremendous relief. When I read this, it took me a second to kind of process it, but it really means, for the vast majority of my clients, a lot of my clients are here in the United States on F1 status. They're on OPT, they're a student, and this proclamation, they will not be subject to the $100,000 fee so long as they change status here in the United States. So as you can imagine, this is a huge benefit for international students, at least in my mind. Yeah.
Awesome. We already have some questions flowing in. I'll just pop them up on screen one by one. So the first one is by Aditya. He asks, I'm graduating in spring of 26, which is the coming January. If I get selected for lottery, anything in the future, when I go home for stamping, will my employer still have to pay $100,000 fees?
No, but here's what you need to do. You need to do change of status here in the United States from your F1 to H-1B. You should not on the I-129 form. The employer has the right to select consular processing or change of status. If they select change of status and they get that H-1B approved, you can you will be able to go home and pick up a visa so you can travel freely like you can right now or in the past. But if you select consular processing, you're subject to the fee. So be careful.
Got it. There's another question from Instagram. Dikshita asked, my H-1B got picked this year, so my STEM OPT is going to end. Can I still apply for premium processing for H-1B right now? My application is still pending as of now.
My H-1B was picked this year. Well, so long as if there's a valid job offer and the employer verifies that, this should not be a problem at all. You can apply for premium processing.
Got it. So just to clarify, since you are going to be making a change of status in the US, make sure your employer files it as change of status and not consular processing, as
Absolutely.
Daniel just mentioned. And it's very important that once your change of status is approved in the US, only then you go for any sort of stamping or whatever you need to do.
Right.
And premium processing can definitely help expedite that. So if that is an option with your employer, please do so.
To add
Okay.
to what you just mentioned, it is essential for people to understand that not to travel during any pending applications. This is the season wherein the H-1B decisions are rolling out right now. And also holidays are coming in and people would want to go back home. But it is very important that people understand that they should avoid traveling when the application is still pending.
Pending, yeah. You should get an adjudication beforehand, before traveling.
Awesome. We have another question from Varsha. So imagine if I'm a student who is planning to come to the US. I'm not in the US yet. I'm planning to get here on F1 visa or J1 visa in 2026. Will the same rule apply to me as well, or would it have changed for me?
My understanding of the rule is that, like, it will, if you're here on a valid F1 status, you will be able to change status to H-1B in future lottery years. They have not restricted it. Like the 2027 lottery, as it stands right now, all of this stuff is still kind of up in the air. But the structure that they've created right now, it appears that future lotteries periods will not be subject to this $100,000 fee. Based on this update on the website. I do want to caution that this is a highly volatile area and this stuff could change. And also the legality of the $100,000 fee is challenged in court. So like a year from now, do I really know if this $100,000 fee is likely to be applied? I have no idea, actually, because it's I think the legal challenges to this are robust, and it's a pretty fluid situation. But if you're talking about it today, you should be okay.
Also, we haven't heard any of the employers as of now who have paid these fees, right? Ever since, it's been a month almost, and we haven't heard of any employers who have actually paid the fees.
They would not have been able to pay the fee because the instructions for the fee was only issued this past Monday. There was no announcement. It was just like the website was updated, and they have it on pay.gov, and they explain. I just looked at it just a minute ago. The company will have to use ACH to pay the $100,000 fee, but prior to Monday, there was no employer in the United States who's ever paid this fee because there was no instructions on how to pay the fee. So now there's instructions. We'll see if there's going to be, who's paid it. I have not heard of a single case yet. So, yeah.
Got it. Can you actually break down how the payment of that fees actually works? Like, what does the employer need to do if someone wants to know over here?
Well, they have to follow the instructions on the website. Hold on one second. I just saw it a minute ago, but it basically, you pay on pay.gov, and it was an ACH transfer. It needs to be paid by the employer. Let's see, anything else? Give me a second.
Got it. Till
Yeah,
then, I'll just yeah. Go ahead.
yeah, apparently they have to create an account for this. Yeah, I'm not sure actually right now. Yeah.
Also,
I
also the options on pay.gov are not very, I mean, they do not have designated option for paying the H-1B fees as of now, I believe.
no, they
Just
it it looks to me like it's operational, but like like it seems that they're asking like who the type of petitioner, individual or company, the mailing address, contact information, tax ID number. Yeah, I think that, and then they just list the 100,000 KC. If okay, interesting. If your application is not approved, a full refund will be processed. Interesting. I didn't know that, but
That's actually great to hear as well. Yeah. Let's move on to the next one. Is the upcoming lottery going to be salary based? Like we all heard that there were rumors that there is four different wage levels would have different
the
percentages assigned to them.
So,
And
is it coming H-1B? It's in the process right now. The rule has not been fully implemented. It has not been. It's still in the notice and comment. It's been announced. I want to clarify that this is not a salary-based H-1B rule. It is based on the field that you are in. So, for instance, um, a very, very experienced architect who makes $100,000, they're the level 4 wage, will get a much, much higher chance than a machine learning specialist who is maybe just a fresh out of college. Even though their salary, maybe the machine learning specialist salary is 300K starting or 200K, but it's not based on just salary. It's based on your field, in your industry. So, and also by the location you're in too. So, like if you were in Boise, Idaho, or the salaries usually tend to be much lower there than here in the Bay Area, and so like your chances are higher over there. So that's all. It's all factored into this.
got it. Has it
Um,
already been applied? Like, has that
no,
ruling passed?
no, it has not. It has been proposed, and it's going on through the notice and comment sections right now. I still I don't have a very good sense if it's going to make it in time for um uh, the upcoming lottery. Things. I have some doubts. I have some real doubts that it's going to make it because the Immigration Nationality Act has clear language that it's a first come first serve basis for the H-1B, and they did not anticipate when they wrote the Immigration Nationality Act and the rules about H-1B. They did not ever anticipate counting it in this way of preferencing based on the field and then the level of the salary that you're in. So I think that it's quite possible that this will not apply for this upcoming lottery. I think you know I think that the court, it's still up in the air. We'll have to see about it. But like, I think that the legal challenges to this rule are robust, and the language in the Immigration Nationality Act really does preference. It makes it so that it should be just first come first serve for the H-1B, and in the order that it's counted.
Got it.
Yeah.
We have a very interesting question here. So I previously had an H-1B visa, but didn't use the full duration and returned to India.
Yeah.
I'm currently waiting for my I-140 approval from India. Is there a chance of removing the $100,000 requirement that there is? And this person also posted an updated question.
Hmm.
So they basically are trying to ask, like, if I'm currently in India and waiting for my I-140 approval from India, would I still have to pay it? If I do, like, is there a chance of it getting removed?
Well, is the H-1B still? My question about this is: the H-1B job still available? Did they did they go to India and then they quit their job? If that's the case, then you're subject, you know. But if you were like, let's say you were on leave and you were in India for a prolonged period, I think you make the argument that like, hey, you know, this my job's still there, and you get an employment letter from them. It doesn't matter about your I-140. You know, like you're waiting for this approval. It matters like, are you still working on that H-1B job? If you
Yeah.
are, or you know, like they put you on some kind of leave, maybe you can reactivate that H-1B, and this won't apply at all. That's you know,
Got
yeah.
it. Got it. So the first thing to make sure is that if they still have the job. If you are still here,
If
Santosh,
you,
do post
um,
your update in the comments.
yeah.
Yep. Anjali asked that I'm going to graduate in spring again. And is it true that the duration of landing a job, like the unemployment period after you graduate, has been reduced? Is that true?
I have not heard confirmation about that. No, I have not heard that.
No official update on this thing.
No, I haven't heard of any update. Perhaps I'm wrong. You know, there's an information overload, um, and so like I could imagine that this has changed, but I have not heard that.
Got it. So the point over here is only trust official sources directly, either from USCIS, DHS, or the White House itself. If you
Yeah,
are hearing anyone else saying something else, that's just all speculation. They're trying to spread rumors, just trying to create hysteria. Don't follow all of that. Just follow the official pages. They do a very good job at updating it every now and then. So do try
absolutely,
following that.
In addition,
absolutely.
there's an F1s too. I mean, and if any of them are the students, please make sure to contact your international office at your
Yeah, the
university.
designated student officer at your university. You know, for international students, I cannot stress this enough that the designated student officer is the point person for all of these issues, and they should be able to explain, like, hey, this is what the grace period is for OPT. This is what the this is how you change if you needed to. You know, all sorts of any kind of issues. They are the person that you're supposed to contact when you're a student. The whole system was designed so that they would be the focal point for this, not people like me, the lawyers.
Got it. But yeah, people like you actually have the legal expertise to give proper answers on this.
Right.
So I think it's definitely beneficial for everyone to just hear and get a, like, not a legal opinion per se, but a person with the legal expertise, their take on the situation.
Absolutely, I agree, but I do think that like when you know when you are an international student, um if you have questions about this, the first person you should ask is your designated student officer,
Yeah.
because and then you should evaluate like if they seem like they know what they're talking about, like you know universities are of a various quality, and you know like the staff, you might have a DSO that's maybe not so knowledgeable about this. That's where you might want to seek a second opinion. But in general, like the first point of contact is that DSO.
The immediate contact person that might give you the relevant information is the
Yeah.
DSO and also the international office in general at the school.
Right.
I
Right.
know of a lot of schools who also they keep on hosting weekly webinars for international students just to give the updates in these times. It is, I would say, it is important and essential to also have your focus there.
Yeah.
Got it.
Exactly.
Yep, definitely. We have another question from Instagram this time. Can my H-1B be transferred? So I think what they're trying to ask is, if I am on an H-1B working for company A, can it be transferred to company B without having to go through all the fees and every
Yeah.
debacle that
It
they
should.
have?
That should be fine. That should be fine. Change of it's as long as
Got it.
you're in the United States. If you're as long as you're here in the US.
Got it. So just to sum up what everything that we have talked about so far, but by the way, if you have any more questions, guys, feel free to drop it in the comments either on Instagram or on YouTube. We are taking each and every comment right now and answering whatever questions you have. Just to sum it up, if you are on a legal status in the United States, you first of all, if you want to transfer to H-1B without having to be subject to the $100,000 fees, you need to complete your change of status while in the US. You cannot leave the country, you cannot be in any third country. You have to be within the US,
Absolutely.
borders of US to complete the status. And then once the approved status arrives for you, you can travel either for stamping or for any other purposes. But to re-enter, you would need your stamped visa whenever you do have to re-enter the United States. A few other questions that we were asked right now is everything to do around H-1B. If you are either waiting for your final approval for H-1B, you want premium processing and all of those things, they are not subject to the $100,000 fee as long as you are in the US.
Right.
Okay, there's another question over on Instagram where like they're just asking about the lawsuits that are currently challenging or opposing the 100K requirement and how likely are they supposed to get succeed. Like we were just discussing, me
I'm
and
actually very
Daniel.
hopeful.
Yeah.
So there's an attorney, Greg Siskrin, and he's been very, very vocal in organizing the one of the lawsuits. And the lawsuit, if you read the complaint and the plaintiffs involved, they're very, very sympathetic plaintiffs. These are not tech workers. They are nurses. They are language teachers at high schools and colleges. They are union members who are affected by this $100,000 fee. So I take solace that I actually think that I personally think the $100,000 fee is illegal. Like that it's very likely that there's going to be the courts will curtail it. I think that I would not say that is it I cannot say if it's going to be completely overturned or not, or if there's going to have it. The legal basis for it, essentially the proclamation the president issued is a travel ban, and the travel ban has been upheld in courts with the Hawaii decision. And I think that it's very likely that although I believe that the challenge is great, there's a good chance, there's both sides have great arguments. And so I think that it's hard to say at this point which one is going to win this.
There are a lot of gray areas
absolutely.
But in addition to it, everybody has to understand that there have been precedents, even in the Trump 1 era, as Daniel mentioned, the Trump versus Hawaii, and that ban was upheld and that was allowed. Even after the clarifications which have been given, there are a lot of questions to be answered, a lot of gray area clarifications to be given, but it is not solely to be said that it is likely to
it's not completely absurd. During the there was the first iteration of the travel ban seemed extremely prejudicial. In this case, my big question is what did they derive this $100,000 fee based on for? H-1B, they already when you file an H-1B, you already pay a fraud detection fee when you that was appropriated by Congress. Congress said that for L's and H's that they pay $1,500 to $750 each case. And when they made that determination, I'm sure they had a good explanation. This is how much we believe this costs to check into this issue. But the $100,000 fee, I have no idea where they got that from. Why didn't they make it $1 million? Why didn't they make it 10,000?
Yep. As we were just talking before this particular live started, what they need to do now is they need to justify the $100,000 fees because that's written in the act. USCIS can only charge whatever is justifiable for that particular application, and they
Exactly.
cannot charge an arbitrary number. So if they
Right.
are able to prove that and everything, the law can be upheld. But if they are not, it is likely, or like there are chances that it might not be upheld, and it can be removed as well.
Absolutely. And there's a lot of other issues with it too. Like, is the president of the United States authorized to issue a fee like this, a fee at all? We don't know. And so like it's not in the Immigration Nationality Act, and the other travel bans, there was never a fee. There was not like, if you pay this, you can come in. There was nothing like that. There was exceptions. There's a national interest exception. There's also a national interest exception for this. The Trump administration has made it clear that the national interest exception is only going to be applied in very rare cases. We don't actually know what that means. So we're still waiting on that.
Right.
But
Perfect. Okay.
yeah.
Just a heads up for everyone, we are going to be taking 5 or 6 more questions for today's session. And if you have any, please drop them down either in YouTube comments or on Instagram. We'd be more than happy to take as many as possible, as much as the time permits. So the next one, it's like a pretty give and tell question. How much is it recommended for traveling internationally from the US if you are here on a visa?
Well, if you are here on an F1 status and you have a lot of time left on your F1, I do not discourage international traveling at all. If you but if you have a pending H-1B, of course I do not want you to travel at this time. I think if you should get that case approved beforehand. Okay. But if you're in like a valid status and you don't have any normal impediments, is it possible that another one of these executive proclamations could come down the pipeline? Yeah, it could, but life happens. And, if you're if you're traveling for especially good reasons, like a lot of my clients do, it's like they have a family issue or something like that. Absolutely. I do not discourage travel at all.
Yeah. So the essential thing to understand is if you have a pending status as of now, like if anything is pending, nothing like don't have the approval, you don't have any rejections or whatever, it's advisable not to travel at this point. But if you are on legal status, if you're on F1 or you have a approved H-1B, if you are on approved L1 or any of those visas, you can safely travel outside the US. That's the general consensus as of now. But
Yeah.
you should always make sure that you have all the necessary documents proving your status, whether it's your EAD card, whether it's your employment letter, pay slips, whatever proves that you are in the legal status. Just carry all of the documents. That's the legal consensus that I'm hearing from everyone
Right.
right now.
I would agree with that. I think that you should also be cognizant of your own individual situation. That like if you're with an employer that maybe is it,
There are just questions.
there's questions about the employer or something like that, or there's questions about your personal background. Of course, I do not just want to say go ahead and travel, but for the general client that has no known impediments, has a maybe a very supportive and established employer, absolutely, I have no problem at all with them traveling.
Got it.
To add to the list that Jugal mentioned of the documents, any F1 student, either on OPT or STEM OPT, please make sure that their I-20 is also signed and is active. I am aware that the signatures do expire. We
Yeah.
students are not aware about it because they are timed and all of that. You just imagine that, oh, I have the I-20, it's all good, it's all sorted. No, you need to ensure that the travel signature is valid from your designated student officer. So that is one thing that you all need to check. And please take your I-20 with you.
Yeah, and I would also for international students, I would again advise to speak to your DSO before you travel. That this situation could change any month, or things. But right now it seems fine. But like if you before your travel, just send an email or contact the DSO, let them know you're about to go, and make sure that you have everything that you need.
Yep. So that's exactly what I used to do when I was in university. Like even now on OPT, before any sort of travel, like 1 month prior to it, I would just send a request that, hey,
Yeah.
I'm traveling internationally. Do I need an updated signature or not? They would
Right.
either get back to me with the updated I-20 with signed with a new signature, or they would just simply mention that your signature is still valid. You can travel without any difficulties. Just carry these documents and you should be good. And I think
Right.
it's the same in every university, no matter where you are.
Right.
Even if you're on your OPT or STEM OPT, you are still on an F1 visa, and that's still
Absolutely. Yeah.
controlled by your DSO. Like your DSO has the right to sign your I-20 at that point as well. So it does not matter if you've been working for 2.5 years. Please make sure that you contact your DSO before you travel, as long as you're on an F1 visa.
Yes, I agree with that 100%.
The next one is I'm thinking to pursue masters in the US. So as an F1 student, what are some rules and regulations that I need to be concerned about? Like, is there anything except what we have discussed right now that people need to be concerned about?
Well, I okay. I want to welcome you here to the United States to study whatever you want to dream about, and to pursue your career things. I think something that I might caution international students. There's been discussions of limiting OPT. The director of USAS has said that, like, in his confirmation hearing, that he wanted to do that. That was one of his goals. Now, have they actually issued a proposal to do that? No, they have not. But I can foresee that on the horizon. So, like, I don't know exactly when you want to study your master's, if it's next year or even sooner or later. But I think if I was an international student abroad, I would check to make sure that OPT is still available. Optimal practical training is still available to international students. STEM or the regular ones. I think
100%.
that, kind of critical.
Yep. So I think this is a half question, like half of it got cut, but I can still see it on Instagram. So what would it be wiser to say to a company if they say that they don't want to sponsor visa and revoked offer letter just because they don't want to sponsor you? But you told them that you don't need sponsorship for 3 years, which is OPT and STEM OPT. Like, what could be the possible scenarios in those cases? Like, I know this is very subjective and it depends from company to company on who they want to hire. But one thing I recommend everyone do before they go ahead and give their interviews is
Yeah.
actually check something called the E-Verify database. It
Yes.
is a list of all the companies who can and have done STEM OPT in the past. For,
Yeah.
for a company to sponsor you on STEM OPT, they need to be E-Verified. And if they are E-Verified, they
Right.
can legally do that. And you can raise a question to the recruiter or the HR that, hey, you guys are legally able to do it. Is there any other reason? Like, they might still reject you, but
Yeah.
that's a valid question to ask them. Like, that's what I would recommend before you even start preparing for your interviews.
And I think that, like, from my end, I advise employers about filing E-Verify all the time. It is not a very arduous process for E-Verify. To register for the E-Verify, even for small companies, it takes less than like an hour or something. It's like it's very fast, and it's done it's completed in a couple days. The whole process. The only thing that from the company's standpoint, their liability is that they have to follow the E-Verify rules in perpetuity. Like, once they sign up for E-Verify, they have to keep on doing it for every single employee that comes by their door. Even an obvious American or not, they still have to apply this. I think the system within 72 hours. I think it's 72 hours. But in any event, they have to do this. I think that, like, one thing I would advise international students and those seeking employers, you know what? This is America, and, like, people switch jobs all the time. You should go. If your employer, if your potential employer seems hesitant about this, sponsoring, find another one. The land of opportunity here. I know that it might be difficult if the economy tanks or whatever, but I still think that, like, if you encounter an employer who seems completely unfamiliar or hesitant about filing this, that your best bet is maybe find another job, find another way.
100%. One of my friends who also, like, does all of this, like, job search and everything.
Yeah.
Like she also faced a similar situation where her employer was not ready to sponsor her visa, and they were
Yeah.
just very hesitant on doing so. She was able to find another job in like a couple weeks, maybe 3 weeks. I'm not sure of the exact timeline,
Yeah.
but you can and you will be able to find other jobs and people who are ready to sponsor, and there are still bunch of companies who do that.
Right.
So the only thing over here is don't lose out on your hope, because there are a bunch of
Yeah.
companies who actually do that.
That's what I agree 100%. There, at least what I've encountered in the field is, some companies are intricately familiar with the H-1B and all the things that are involved with H-1B, and then other companies, they have no idea. There's thousands of companies here in America, and they've never had an H-1B employee in their whole existence, or very few, or the person that the hiring whoever you're talking to doesn't know how this stuff works.
Yeah.
So that's my job, is I explain to companies, hey, this is how this process works, and
Yeah.
it's not as hard as you think and things. But
Exactly.
for the other end, if you're getting some employer where they're like, oh, we don't want to pay these fees, this seems so complicated, we don't know what's going to happen, you know what, you better switch, try to find somebody else.
Yeah,
That's
exactly. I think the follow-up question that that person posted, like that they
Yeah.
are e-verified, but still told me that they will hire citizens or green card workers at this point because they don't want the tension of any sponsorship or anything, which is fair according to company standpoint. And I think at that point you should just be looking
Well,
for.
there's I find that actually kind of interesting. It's that those statements, they have to be careful about that. Like state and federal employment law prohibits discrimination against immigrants, and so like when you have like things like does the company have to do this arduous process to sponsor them? No, they do not have to undergo that. But could they say we only hire Americans? No, they can't do that. There's this line, and I think it's probably violated all the time. But even with that, like these companies should be very, very careful about what they're saying. Like they should not discriminate against immigrants.
Yep, I think that's one of the questions that someone just posted. That if it's not
That's
hiring due
right.
to
It falls under, I think, not hiring due to the future sponsor. Well, I think that like like you wouldn't want to have them put it in an ad, like or something like the future sponsor, that would be clearly illegal. But do they have to undergo this process for you? No, they don't. So
This is now setting up as a trend, Daniel. I've
yeah,
been reading it today about how Walmart is also being reluctant to hire H-1Bs. That has just been in the news today. No
yeah,
official statement, obviously, but
right.
then I don't think that the H-1. I mean, we have the next question, but I don't think that would fall under. Would that fall under the discrimination thing, that they would just not
Well, I
hire
think
people?
they have to be really careful, especially in the ads that they're saying that it could run afoul on the discrimination laws, and I'm sure there's many companies that violate these things.
I mean, they
And
might just
yeah,
reject the application and not say that we are not officially hiring. I mean,
yeah,
that
yeah,
is not.
it's
there,
like same person posted a follow-up about the exact same thing, like what's the legal extent, like legal liability of extent over there.
well,
Like they have an email saying exactly that from an e-verified employer.
well, that's a good question. Like I would advise them to talk to an employment um,
Yeah.
uh, lawyer about that. But they might have a really good case actually. Like I think that like these companies have to be careful about what they're saying. I love Tesla and I love SpaceX, but just a couple of years ago, they were under a huge lawsuit over not wanting to hire people who have EADs, asylum seekers who have EADs in their employment things, and Musk was posting about this on Twitter or X, how upset, but like it was, it's a real lawsuit, like, and the Department of Labor, I believe it was the Department of Labor brought this up to them, And so like you could these are real issues that come up.
Definitely. So if so, the entire conclusion is if they did mention that, do tell them that this is discriminatory practices. They
Yeah, I
might
believe
not
this is
justify it
discriminatory
to you.
practice. Yeah. I if somebody tells you that, like, you know, if they don't hire you, okay. But if they say like we don't this job is not only open to US citizens. What? Like,
Yeah.
you know, what's the
Unless
rationale
it's
for that?
Yeah,
Like,
unless it's like a defense based, like a army contract or space
absolutely.
technology or something like that, they can say that because that requires clearance.
Yes. Yes.
But on normal jobs, which does not require clearance,
No,
they legally cannot say that.
Yeah,
right.
national
Right.
security is always the exception, but
100%.
in general, they just cannot.
Yep. So the next question is it possible to transfer from B1 to H-1B without paying the $100,000 fee?
Yes, it appears to be. So this is actually a really interesting point. The language of the original executive proclamation, they had a section about they were going to study about to make sure the B visas are not misused for the October 1st date, you know, for the H-1Bs. This new guidance or this new guidance language that they issued on the website does not prohibit B1, so it should be fine to change status for this. I do want to point out to your audience about the 90-day rule about changing of status. That it's not a rule of USCIS, it's a rule of the Department of State. But if there's a presumption that within, if you change status within 90 days of coming to the United States, that you might have not really had, you might have had immigrant intent. You know, like this is
Yeah,
a facade, if you will. And, you know, that rule, you want to be careful. You don't want to just come into the United States and the next day change your status, because if you go to a subsequent, you know, get a visa later down the line, they could ask you about this, and you don't want to bring that up. It's not a rule of USAS, but it's in the Foreign Affairs Manual with the Department of State.
100%. So just to sum it all up, what we have talked about so far, and to everyone who's just tuning in right now, just a summary of everything. So as long as you are within the US on a legal status, whether that's F1, you're on an OPT, STEM OPT, you're on L1 visa, you're on your J1 visa, as long as you are in a legal status that is approved, you can change your status to H1B visa without having to pay the $100,000 fee.
Right.
The one thing to keep in mind in this case is while filing that particular petition, as Daniel mentioned previously, your employer would have the option to either choose consular processing or change of status. They should select the change of status, and only once it is approved, you should travel internationally to get your visa stamped. Before that, you should not.
Yes. And you know, this is actually a really interesting point. You know, from I filed these H-1B petitions, and like, you know, sometimes the employer doesn't even know much about like what the student situation is. Like, oh, you know, like I was planning to go home for a wedding and stuff. Now, you know, the options have been clarified. Like, they should always select change of status if they're here in the United States. The student should, you know, unfortunately, the student should they're going to have to provide information that they've maintained their status here in the United States, you know, to get that H-1B approved, you know, to avoid this fee. It raises a stake of this change of status. So, you know, like I've had cases where, you know, it's a perfectly valid H-1B, but then the change of status, there was some kind of problem, you know, with the, you know, they overstayed or something, or some kind of impediment to changing their status, you know, effectively. Before, that was not a big deal. It was like, okay, just go home and pick up a visa. Now it's this huge deal because of the 100,000 fee attaches if you miss if the employer messes it up, or the client doesn't provide the adequate information. You know, yeah, it's just
Just to follow up on that, Daniel, do you think that if the H-1B petition has been approved, are there any chances that the change of status might not be approved and they would push you to the consular processing? Would
Well,
that
there
happen?
is actually, like, I've had it in years past. Change, like, there's been like clients, like, for instance, we had a client who had, I guess it would be, he was at F1 and he withdrew from the university, and I believe there's like a 10-day grace period for that. But on the their change of status, they were denied because they thought they would get the I it was either 30 or 60-day grace period for as a student. But no, it was only a 10-day grace period. And so
When
that they said, your change of status is denied. Now, in the case that we handled, it was not actually an H-1B, but that doing that action in an H-1B context, it would have these huge implications. This $100,000 fee would attach. So I'm actually kind of worried about it.
Got it.
Yeah.
Makes sense. To everyone who joined and asked questions, thank you so much. Just one thing to keep in mind: whatever was said or mentioned in this particular live was not legal advice per se. It was just Daniel sharing his own opinions as a legal immigration attorney and
Yes.
everything that he has been noticing. If you want a legal advice directly from Daniel and his legal counsel, like if you want his legal counsel, feel free to check the link in the description on YouTube. We have a form, the consultation form for their particular entire suite of legal attorneys. They can help you out with your steps, whether you want to apply for O1 visas, whether you want to apply for EB2, national interest waivers, anything to do with immigration. They can take your case. They will tell you what to do, what not to do, and if they can proceed for your particular case. So do fill out that form, and then you can proceed with a legal counsel.
Thank you, Joel.
Awesome. Thank you so much, everyone. If you have any more questions, feel free to drop them down in the comments on YouTube or on Instagram. I will make sure those questions get to Daniel and I will get them answered. And whenever I get those answers, I will reply to you in the comments itself. And thank you so much, everyone, for joining. Thank you, Daniel and Deshna, for your time. Thank you so much.
Thank you, everybody. Have a good evening or day wherever you are.